You are on HOA neighbor court. I stayed calm and let her talk. I am calling the board right now. That was the first thing Tiffany Perez screamed at me, waving a folder above her head like it was a court summons. She stood on my driveway in Boise, Idaho, blocking my car, her face red and her red cardigan flapping as she gestured. The folder, she said, contained everything, and I was not entitled to a copy. I asked what everything meant. She ignored me and kept yelling that I had violated parking rules, that I had missed a mandatory hearing, and that my car was about to be towed within the hour. I work as a nurse in a busy clinic, and my shift started in 90 minutes. A tow threat could get me fired. I had moved to Willow Creek Estates Association 2 years earlier because the rent was reasonable and the neighborhood looked quiet. It was quiet until Tiffany, the rules interpretation chair, decided contractors should be harassed like criminals and residents should be railroaded at hearings with no notice. She claimed she wrote the covenants herself, which was a lie, but no one challenged her because she controlled the meeting agendas and the management company did whatever she asked. I had ignored most of her antics until this moment, when she showed up with a folder and a threat that could cost me my job. She snapped the folder shut and told me the hearing I supposedly missed was 2 weeks ago. I asked for proof I had been notified. She said the notice was sent, but I never got it. I checked my mailbox daily. I checked my email. Nothing. She shrugged and said my failure to receive it was not her problem. That was the first abuse. A notice claiming I missed a hearing I was never told about. She turned and marched back toward her car, shouting over her shoulder that the tow company was already en route and I should move my vehicle immediately or face the consequences. I stood there holding my keys, feeling the pen in my jacket pocket dig into my palm. I was gripping it too tight. Tiffany climbed into her car and slammed the door. She did not leave. She sat there with the engine running, watching me through her windshield, her phone pressed to her ear. I realized she was not bluffing. She was making the call. I pulled out my phone and opened the neighborhood group chat to see if anyone else had been targeted like this. The chat was already lit up. Someone had posted 10 minutes earlier that I was a repeat offender and that I had a history of ignoring HOA rules. The post cited a past incident involving contractor parking that had never happened to me. I had never hired a contractor. I had never been cited for contractor parking. I scrolled through the replies and saw 3 neighbors agreeing with the post, saying they had seen my violations themselves. None of them lived on my street. I called the HOA management company. The receptionist put me on hold for 6 minutes. When she came back, she said there was no record of a hearing scheduled for me. I asked about the towing authorization. She said she would check. Another hold. Another 4 minutes. She came back and told me a tow slip had been filed that morning by Tiffany Perez, citing repeated parking violations and failure to appear at a compliance hearing. I asked how a hearing could be on file if the management company had no record of it. She paused. She said she would escalate this to her supervisor and call me back. She did not call back. Tiffany finally pulled out of my driveway and drove off. I stood there for another minute, trying to decide what to do. My shift started in 75 minutes. I could not risk my car being towed. I moved it to a guest parking spot 3 blocks away, locked it, and walked back to my place. On the way, I passed a kid on a bike who braked hard and stared at me like I had just escaped a disaster. He asked if that lady was going to tow my car. I said I hoped not. He said she had done it to his mom last year over a trash can placement issue, and his mom never got the car back for 3 days, because the tow yard was an hour away and closed on weekends. I thanked him and kept walking. Back inside, I opened my laptop and searched for the Willow Creek Estates Association bylaws and covenants. I found them on the county website. I skimmed the parking section. There was no rule about missing a hearing triggering an immediate tow. There was no rule about compliance hearings at all unless a violation had been documented in writing and sent via certified mail. I had never received certified mail. I took screenshots of every relevant section and saved them to a folder on my desktop. Then I logged into the HOA portal and checked my account. No notices. No fines. No hearing dates. My account was clean. I called the management company again. A different receptionist answered. I explained the situation and asked to speak to the supervisor. She said the supervisor was in a meeting. I asked when the meeting would end. She said she did not know. I asked for the supervisor's direct email. She refused to give it to me. I hung up and searched for the management company's website. I found the supervisor's name and email in the staff directory. I drafted an email explaining the tow threat, the fake hearing notice, and the lack of documentation in my account. I attached the screenshots from the bylaws. I sent it and copied the HOA board president, whose email was listed on the community bulletin board. 10 minutes later, my phone buzzed. It was a text from an unknown number. The message said I had been placed on a compliance watch list, and any further violations would result in immediate fines and legal action. The text was unsigned. I called the number. It went to voicemail. The voicemail greeting was Tiffany's voice. She said she was unavailable and to leave a message or contact the HOA office. I did not leave a message. I took a screenshot of the text and saved it. I left for my shift. My car was still in the guest lot when I got there. I drove to the clinic and worked a 12-hour shift. When I got home at 2 in the morning, there was a notice taped to my front door. It was printed on Willow Creek Estates letterhead. The notice said I had been fined $300 for unauthorized parking in a guest spot, and that my vehicle was subject to towing if not moved to my assigned space within 24 hours. The notice was dated 2 weeks earlier. The date stamp was fake. I had only moved my car that afternoon. I peeled the notice off the door and took it inside. I laid it flat on my kitchen counter and took photos under bright light. The paper was fresh. The ink was sharp. The tape residue on the back was still sticky. It had not been on my door for 2 weeks. I texted the supervisor at the management company. I sent the photos of the notice and explained that the date was backdated. I asked for an immediate investigation. I did not get a reply. I went to bed and slept 4 hours. When I woke up, I checked my phone. No reply from the supervisor. No update in the HOA portal. I called the management company again. The receptionist said the supervisor was out of the office for the day. I asked when she would return. She said tomorrow. I hung up and decided I needed help. I called a neighbor I had met at a community barbecue 6 months earlier. His name was Dennis, and he worked as a gate vendor technician for a security company that maintained the neighborhood access system. Dennis answered on the second ring. I explained what was happening. He said Tiffany had pulled the same stunt on 3 other people in the last year. He said she used fake violation notices with altered dates and recycled photos to justify fines and towing threats. He said the management company knew about it, but did nothing, because Tiffany was tight with the board president and the tow vendor. He said I needed to gather proof and escalate to someone outside the HOA system. Dennis offered to pull the access logs for the neighborhood gate system. He said the logs would show when my car entered and exited the community, and whether Tiffany or anyone from the tow company had accessed the gates during the time frame she claimed I was violating rules. I asked if he could do that legally. He said the logs were part of his maintenance contract and he had permission to review them for troubleshooting. He said he would send me a summary by the end of the day. I thanked him and hung up. I spent the next hour reviewing the neighborhood group chat. The post about me being a repeat offender was still pinned at the top. I clicked through the profiles of the 3 neighbors who had replied. 2 of them had joined the chat within the last month. The 3rd had never posted before. I searched their names in the county property records. None of them owned property in Willow Creek Estates. They were fake accounts. Someone had created them to build a fake paper trail against me. I took screenshots of the profiles in the chat thread and added them to my evidence folder. At noon, I drove to the clubhouse to request copies of all HOA meeting minutes from the last 2 years. The clubhouse was a low beige building with a tile roof and a row of mailboxes out front. I parked in the guest lot and walked to the office door. It was locked. A sign on the door said office hours were Monday and Wednesday from 10 to 2. It was Friday. I knocked anyway. No one answered. I took a photo of the sign and the locked door and added it to my folder. On my way back to my car, Tiffany appeared at the end of the walkway. She was holding her megaphone. She used it to announce that I was trespassing and that she was filing another violation notice for unauthorized use of guest parking. I asked her how I could be trespassing at the clubhouse when I was a resident. She ignored the question and raised the megaphone again. She said I had no right to request meeting minutes without board approval and that my request was being denied. I asked who gave her the authority to deny records requests. She said she did not need authority because she had paperwork and vibes. I repeated her words back to her slowly. Paperwork and vibes. She nodded and said yes, exactly, and that I should leave immediately or she would call the police. I pulled out my phone and started recording. I held the phone at chest level and narrated what was happening. I said Tiffany was blocking my access to HOA records and threatening me with police involvement for requesting public documents. She lowered the megaphone and stepped closer. She said I was not allowed to record her. I said I was standing on common property and had every right to record. She said she would make an example out of me so everyone learns. I asked what everyone would learn. She said they would learn not to question her or the board. A car pulled into the lot. A woman in her 50s stepped out and walked toward us. She worked for the management company. I recognized her from a photo on their website. She asked what was going on. Tiffany said I was harassing her and refusing to leave. I said I had come to request meeting minutes, and Tiffany had denied my request without cause. The woman from the management company looked at Tiffany and asked if that was true. Tiffany said I had not followed proper procedure. The woman asked what the proper procedure was. Tiffany said residents had to submit a written request to the board president and wait for approval. The woman said that was not accurate and that records requests were handled through the management company under state law. Tiffany turned red and said the woman was overstepping her role. The woman ignored her and asked me for my name and address. I gave them. She said she would email me the meeting minutes by Monday. Tiffany raised the megaphone again and said the minutes were confidential. The woman said they were not confidential and that Tiffany needed to stop interfering with records requests. Tiffany lowered the megaphone and walked back to her car without another word. I thanked the woman and left. If you are enjoying this story, hit that like button and subscribe for more HOA revenge stories, where the paperwork always wins. That evening, Dennis texted me the gate access log summary. He said my car had entered the community at 8:15 that morning and exited at 9:45. It had returned at 2:30 in the afternoon and had not moved since. The log showed no violations. Dennis also said Tiffany had accessed the gate system using a master override code at 3:10 that afternoon and had logged the access as a compliance inspection. He said the override code was supposed to be used only for emergencies and that using it for compliance inspections was a violation of the vendor contract. He said he was filing a report with his company and copying the HOA board. I thanked him and asked if he could testify to what he found if it came to a hearing. He said yes. I added his contact information to my evidence folder and marked him as an ally. I now had the gate logs, the screenshots of the fake group chat posts, the backdated notice, the recording of Tiffany denying my records request, and Dennis as a witness. I felt like I had enough to push back, but I wanted more. I wanted to know why Tiffany was targeting me and whether this was connected to something bigger. I spent the weekend digging through old neighborhood forum posts and archived HOA meeting minutes. I found a thread from 3 years earlier about a missing HOA reserve fund. A resident had questioned the treasurer about a $20,000 discrepancy in the budget. The treasurer said the money had been spent on landscaping and legal fees. The resident asked for receipts. The treasurer said the receipts were filed with the management company. The resident requested copies. The management company said the receipts had been lost in a server migration. The thread ended there. No resolution. No follow-up. The resident who had raised the issue moved out of the neighborhood 6 months later. I cross-referenced the dates in the thread with the HOA meeting minutes. The treasurer at the time was Tiffany Perez. She had been on the board for 5 years. She had served as treasurer for 3 years before moving to the rules interpretation chair role. I searched for any financial audits conducted during her tenure. There were none. The bylaws required an annual audit, but the minutes showed the board had voted to waive the audit requirement every year since Tiffany joined. I now had a theory. Tiffany was covering up financial mismanagement or theft by targeting residents who asked questions or requested records. The fake violations and backdated notices were not about parking or compliance. They were about intimidation. She was using the HOA enforcement process to silence anyone who might expose what she had done. I did not have proof yet, but I had a direction. On Monday morning, I received the meeting minutes from the management company. The email included PDFs of every board meeting from the last 2 years. I printed them all and spread them out on my kitchen table. I went through them page by page, highlighting every mention of fines, towing, compliance hearings, and records requests. I found a pattern. Over the last 18 months, Tiffany had initiated compliance actions against 12 residents. 8 of those residents had requested financial records or questioned board spending in the months before they were targeted. 3 of them had been threatened with towing. 2 had been fined. 1 had been sued by the HOA for unpaid fines and legal fees. All of the compliance actions had been initiated using notices that were dated weeks or months before the residents claimed to have received them. I pulled up the county records for the HOA and found the registered agent. It was a law firm in downtown Boise. I called the firm and asked to speak to someone about HOA compliance issues. The receptionist transferred me to an attorney named Laura Chen. I explained the situation and asked if backdating notices and denying records requests were legal. She said they were not. She said residents had a statutory right to inspect HOA records under Idaho law, and that backdating enforcement notices was fraud. She said I could file a complaint with the state attorney general or sue the HOA in small claims court. She also said I should document everything and consider filing a police report if the harassment continued. I thanked her and hung up. I did not want to sue yet. I wanted to catch Tiffany in the act and force the board to remove her. I needed a smoking gun. I needed proof that she was fabricating violations and using the tow company as muscle. I decided to set a trap. That afternoon, I parked my car in my assigned spot and installed a new doorbell camera on my front porch. The camera had motion detection and cloud recording. I angled it so it would capture anyone approaching my door or my car. Then I sent an email to the HOA board president. I said I was concerned about the recent compliance actions against me and requested a formal hearing to address the violations. I copied Tiffany on the email and waited. 2 hours later, Tiffany replied. She said my hearing request had been received and that I was required to attend a compliance review meeting at the clubhouse on Wednesday at 6 in the evening. She said failure to attend would result in additional fines and immediate towing. She did not say what violations would be discussed. She did not provide any documentation. She did not explain why I had supposedly missed a previous hearing. She just set a date and threatened me again. I replied and asked for a written summary of the alleged violations and copies of any notices or warnings I had been sent. She did not reply. I forwarded the email chain to the management company supervisor and asked for clarification. The supervisor replied within an hour. She said she had no record of a compliance review meeting scheduled for Wednesday and that Tiffany did not have the authority to schedule meetings without board approval. She said she was escalating the issue to the board president and would update me by the end of the day. At 5:30 that evening, I received another text from the unknown number that I now knew was Tiffany. The message said I was in violation of guest parking rules again, and that my car would be towed at 7 in the morning if not moved. I checked my doorbell camera. My car was in my assigned spot. It had not moved since I parked it that afternoon. I took a screenshot of the text and checked the camera feed. At 5:15, Tiffany had walked up to my car, taken a photo of it with her phone, and walked away. The camera captured her face and the phone clearly. I downloaded the video and saved it. I replied to the text and said my car was in my assigned spot and had been there all day. I said I had video evidence proving it. Tiffany did not reply. At 6:45, a tow truck pulled into the neighborhood. I watched it on the camera feed. The truck stopped in front of my car. The driver got out and walked around the car, checking the license plate and the parking spot number. He pulled out a clipboard and looked at a piece of paper. Then he pulled out his phone and made a call. He talked for 2 minutes, shook his head, and got back in the truck. The truck left without towing my car. I called the tow company the next morning. I asked why a truck had been dispatched to my address. The dispatcher said they had received a towing authorization from the Willow Creek Estates HOA for a vehicle in violation of parking rules. I asked for a copy of the authorization. She said she could not provide it without HOA approval. I asked who at the HOA had submitted the authorization. She said Tiffany Perez. I asked what time the authorization had been submitted. She said 5:20 in the evening. I thanked her and hung up. I now had proof that Tiffany had submitted a fake towing authorization 20 minutes after taking a photo of my car in its assigned spot. I had video of her taking the photo. I had the text threatening the tow. I had the dispatcher confirming the authorization time. I had everything I needed to prove she was fabricating violations. But I did not stop there. I wanted to find out what she was covering up and why she was so desperate to silence me. I went back to the archived meeting minutes and pulled every financial report from Tiffany's time as treasurer. I compared the reported expenses to the actual vendor invoices listed in the minutes. The landscaping expenses did not match. The minutes said the HOA had spent $15,000 on tree trimming and irrigation repairs in 1 year. The invoices listed in the appendix added up to $8,000. I searched for the missing $7,000 in other budget categories. It was not there. The money had disappeared. I called Dennis again and asked if he had access to vendor payment records. He said he did not, but he knew someone who worked for the accounting firm that handled HOA audits. He said he would ask. 2 hours later, he texted me a name and phone number. I called the number. A woman named Rachel answered. She worked as a junior auditor. I explained what I had found and asked if she could confirm whether the HOA had conducted any audits during Tiffany's tenure as treasurer. She said she could not discuss client information, but she could confirm whether an audit had been conducted. She checked her records and said no audits had been performed for Willow Creek Estates in the last 6 years. I thanked her and hung up. I now had proof that Tiffany had been treasurer during a period when thousands of dollars went missing and no audits were conducted. I had proof that she was using fake violations and harassment to intimidate residents who asked questions. I had video of her fabricating a towing authorization. I had testimony from Dennis and the gate access logs. I had the doorbell camera footage. I had everything I needed to take her down. But I still did not know how deep the cover-up went or whether the board president was involved. On Wednesday morning, I received an email from the board president. His name was Greg. He said he had reviewed my complaint and the documentation I had provided. He said the board took allegations of misconduct seriously and would conduct an internal investigation. He said the compliance review meeting scheduled by Tiffany had been canceled and that I would not face any enforcement actions while the investigation was ongoing. He said he would update me within 2 weeks. I did not trust him. I had learned that Greg and Tiffany had been on the board together for 4 years. I had learned that Greg had voted to waive the audit requirement every year. I had learned that Greg's landscaping company had been awarded multiple HOA contracts during Tiffany's time as treasurer. I suspected he was part of the scheme. I decided to go over his head. I drafted a formal complaint to the Idaho Attorney General's office. I attached all of my evidence, the backdated notices, the fake group chat posts, the gate access logs, the doorbell camera footage, the tow authorization timeline, the financial discrepancies, and the audit records. I explained that the HOA was violating state law by denying records requests and using fraudulent enforcement actions to silence residents. I mailed the complaint via certified mail and kept a copy for my records. 3 days later, I received a reply from the Attorney General's office. They said they were opening an investigation and would contact the HOA management company and board for records. They said the investigation could take several months and that I should continue documenting any further harassment or retaliation. I felt relieved, but not satisfied. I wanted Tiffany gone now, not in several months. That weekend, I attended a neighborhood block party. It was held in the common area near the clubhouse. About 30 residents showed up. Tiffany was there, wearing her red cardigan and standing near the barbecue grill with a tablet in one hand. She was showing the tablet to a small group of people and gesturing toward me. I walked over to see what she was saying. She did not stop me. She turned the tablet toward me and said it contained a full record of my violations and that I had been warned multiple times. I asked to see the screen. She pulled the tablet away and said I was not entitled to see it. I said that was convenient. One of the neighbors in the group asked what was going on. I said Tiffany was accusing me of violations that did not exist and refusing to provide evidence. Tiffany said I was lying and that the board had full documentation. I said I had requested that documentation and been denied. The neighbor looked at Tiffany and asked why she would deny a records request. Tiffany said she did not have to explain herself to anyone. The neighbor, a woman in her 60s, said she had requested financial records the previous year and had been told the same thing. She said she had given up because she did not want to be harassed. Another neighbor chimed in and said he had been fined for a trash can violation that he had proof did not happen. A third neighbor said Tiffany had threatened to tow his car over a guest parking issue even though his guest had left hours earlier. The group started to turn. Tiffany realized she was losing control. She raised her voice and said everyone was ganging up on her because they did not want to follow the rules. She said I had been stirring up trouble and spreading lies about her and the board. I pulled out my phone and said I had video proof of her submitting a fake tow authorization. I offered to show it to the group. Tiffany said I was not allowed to record her or share footage without her consent. I said the footage was taken on my property and I had every right to share it. I played the video on my phone. The group watched as Tiffany walked up to my car, took a photo, and walked away. Then I played the timestamp on the tow truck dispatch log showing the authorization was submitted 20 minutes later. The group went silent. Tiffany said the video was edited and that I was trying to frame her. I said the video was unedited and that I had submitted it to the Attorney General's office as part of a formal complaint. The group erupted. People started shouting questions at Tiffany. Someone asked if she had been stealing HOA money. Someone else asked why the board had never conducted an audit. Tiffany said she did not have to answer to a mob and that the board would address all concerns at the next meeting. She turned and walked away. The group continued talking. Several people asked me for copies of my evidence. I said I would share everything I had with anyone who wanted it. I gave them my email address and told them to reach out. By Monday, I had received emails from 8 residents asking for copies of my evidence. I sent them everything: the financial discrepancies, the fake violations, the doorbell footage, the gate logs, and the Attorney General complaint. I also sent them a summary of the cold case I had uncovered, the missing reserve funds, and Tiffany's role in covering it up. The group decided to organize. We formed a coalition and agreed to attend the next board meeting together. We also agreed to nominate new candidates for the upcoming board election and challenge Greg and Tiffany's seats. The next board meeting was scheduled for 2 weeks later. I spent those 2 weeks preparing. I printed copies of all my evidence and organized them into binders. I printed one binder for each board member and one for the management company representative. I also printed extra copies for any residents who attended. Dennis agreed to come and testify about the gate logs. Rachel, the auditor, agreed to provide a written statement confirming that no audits had been conducted. The coalition grew to 15 residents. We coordinated our questions and planned our strategy. We decided to focus on 3 demands: remove Tiffany from the board, conduct an independent audit, and change the hearing rules to prevent residents from being railroaded. The day before the meeting, I received an email from Greg. He said the board had completed its internal investigation and found no evidence of misconduct by Tiffany or any board member. He said my complaint had been dismissed and that further harassment of board members would result in legal action. I replied and said I had submitted my complaint to the Attorney General and would be presenting my evidence at the meeting. He did not reply. The meeting was held at the clubhouse. The coalition arrived early. We set up in the back row and placed our binders on the table. Tiffany and Greg sat at the front table with 2 other board members. The management company representative, the woman I had met at the clubhouse weeks earlier, sat to the side. About 20 other residents filled the room. Greg called the meeting to order and started with the usual agenda items: landscaping updates, covenant enforcement, and budget approvals. He did not mention my complaint or the Attorney General investigation. After 30 minutes, Greg opened the floor for resident comments. I stood up and walked to the front. I said I had submitted a formal complaint to the board regarding fraudulent enforcement actions and financial mismanagement. I said the board had dismissed my complaint without conducting a real investigation. I said I had evidence proving that Tiffany Perez had fabricated violations, submitted fake towing authorizations, and covered up missing HOA funds during her time as treasurer. I said I was now presenting that evidence to the board and the residents. I did not stop her, because I wanted her on record. Tiffany stood up and said I was out of order and that I was not allowed to present evidence without prior approval. I said the bylaws allowed residents to speak during the comment period and that I had every right to present my evidence. Greg said I had 2 minutes. I said 2 minutes was not enough. The management company representative stood up and said state law required the board to allow residents to present relevant evidence during meetings. Greg reluctantly agreed to extend my time. I opened my binder and began. I showed the backdated notices with timestamps that proved they had been printed recently, not weeks earlier. I showed the fake group chat posts with profiles that did not match any real residents. I showed the gate access logs proving Tiffany had used the override code for a fake compliance inspection. I showed the doorbell camera footage of her taking a photo of my car and the tow authorization timeline proving she had lied to the tow company. I showed the financial discrepancies from her time as treasurer and the audit records proving no audits had been conducted. I showed the Attorney General complaint and the response confirming an investigation was underway. Tiffany interrupted. She said I was defaming her and that she would sue me for slander. I said defamation required false statements and that everything I had presented was documented and verifiable. She said I was manipulating the evidence and that the board would not tolerate my attacks. I said the board had already dismissed my complaint without reviewing the evidence and that I was now forcing them to confront it in public. Greg tried to shut me down. He said my time was up and that the board would review my evidence in private. The coalition stood up and said they also had evidence and wanted to speak. One by one, they presented their own stories of fake violations, harassment, and denied records requests. The room erupted. Residents who were not part of the coalition started shouting questions at Tiffany and Greg. Someone demanded an immediate vote to remove Tiffany from the board. Someone else demanded an independent audit. Greg pounded the gavel and said the meeting was out of order. Tiffany grabbed her megaphone and said she would make an example out of me, so everyone learns. The management company representative stood up and said the board was violating open meeting rules by refusing to allow residents to present evidence, and that the meeting could be invalidated if it continued this way. Greg froze. He looked at Tiffany. She looked at him. The room went silent. Then the representative said she had received a copy of my complaint from the Attorney General's office that morning and had been instructed to cooperate fully with the investigation. She said the investigation included a review of all HOA financial records and enforcement actions from the last 5 years. She said the HOA's insurance policy was at risk because harassment claims had been filed by multiple residents, and the carrier had flagged the association as high risk. That was my trump card. I had obtained an HOA insurance document showing their coverage was at risk because of harassment claims. I had not revealed it earlier because I wanted Tiffany on record first. I brought a printed evidence packet in a binder and slid copies to the board and the room at once. The insurance document was in the appendix. It showed that the carrier had received 4 harassment complaints in the last year. and had sent a notice to the board warning that coverage would be terminated if the complaints were not resolved. The notice was dated 2 months earlier. Greg and Tiffany had ignored it. The room exploded again. Residents demanded answers. Greg stammered and said the board was addressing the issue. Tiffany said the complaints were frivolous and that the insurance company was overreacting. The representative said the complaints were not frivolous and that the board's failure to act had put the entire association at risk. She said she was recommending immediate action to remove Tiffany from her position and to implement new hearing rules to prevent retaliation against residents. She also said she was recommending an independent audit and a formal apology to all residents who had been harassed. Greg called for a recess. The board members huddled in the corner. Tiffany argued with them in a loud whisper. After 10 minutes, Greg returned to the table and said the board was voting to suspend Tiffany from her position pending the outcome of the Attorney General investigation. Tiffany screamed. She said she had done nothing wrong and that the board was throwing her under the bus. She said she would sue the board, the management company, and me. She grabbed her megaphone and stormed out of the meeting. The vote passed 4-0, with Tiffany abstaining because she was no longer present. The board also voted to hire an independent auditor and to change the hearing rules so residents could not be railroaded. The representative said she would work with the coalition to draft new procedures. The meeting adjourned. Outside, Tiffany was waiting on the clubhouse exterior walkway as people arrived for the next community event. She was holding a folder and screaming into her megaphone that the board had betrayed her and that she would fight back. Several residents walked past her without stopping. A few stopped and asked why she had lied to them. She said she had not lied and that I had manipulated everyone. I walked past her without saying anything. She followed me with her phone camera raised, recording. I turned and said calmly that she was now on video harassing a resident after being suspended from the board, and that I would be adding this footage to my complaint. She lowered the camera and walked away. The next day, the management company sent an email to all residents announcing that Tiffany Perez had been placed on a no-contact directive by management and was prohibited from initiating any enforcement actions or contacting residents about HOA matters. The email also announced that the board had scheduled a special election to fill her seat, and that nominations were open. 3 coalition members filed to run. The election was held 6 weeks later. All 3 won. The independent audit was completed 3 months later. It confirmed that $7,000 in HOA funds had been misappropriated during Tiffany's tenure as treasurer. The auditor recommended filing a report with law enforcement. The board voted to do so. The district attorney's office opened a criminal investigation. Tiffany was charged with theft and fraud. She pleaded no contest and was sentenced to probation and ordered to repay the missing funds. She also agreed to resign from the board permanently and to have no further involvement in HOA governance. The Attorney General's investigation concluded 6 months later. The office issued a formal finding that the HOA had violated state open meeting laws and records access laws. The office ordered the HOA to implement new compliance procedures and to conduct annual audits. The office also issued a public reprimand to Greg for his role in covering up the financial discrepancies. Greg resigned from the board shortly after. The coalition took control of the board and implemented sweeping reforms. We changed the hearing rules to require advance notice and documentation for all enforcement actions. We required all violations to be sent via certified mail with proof of delivery. We banned the use of towing threats without a formal hearing. We required the board to post all financial records online and to conduct quarterly budget reviews. We also fired the tow company and hired a new vendor with strict oversight. The funny karma moment came when we discovered that Tiffany's favorite fee, a $5 monthly newsletter printing charge, was imaginary. It had never been authorized in the budget and had been pocketed by her for 3 years. The ledger showed she had collected over $6,000 from residents for a newsletter that was never printed. The auditor flagged it as additional theft. Tiffany had to repay that too. The neighborhood is quieter now. Contractors are no longer harassed like criminals. Residents are no longer railroaded at hearings. The HOA operates transparently and accountably. I still live here. I still work my shifts at the clinic. I still check my doorbell camera every morning, but I do not need to anymore. The system works now. Keep your cool, and I will see you next time.